Fenwick Thompson and Associates, many of our family law cases are contested, and most times the contested issues revolve around the children, if not property. So in determining whether one party should have custody over the other, sometimes the courts appoint or sometimes the parties request for a guardian ad litem to be appointed. And a guardian ad litem in the state of Georgia is a licensed attorney. I have also served as a guardian ad litem to represent the best interests of the child. When a guardian ad litem is appointed in a case to represent a child, we are the voice of the child. We become the voice of the child in the litigation, because ideally you don't want your child in court and being exposed or subjected to the court proceedings. So it protects the child, but it still affords the child and allows the child to be a part of what is going to happen to the child in placement or in custody. A guardian ad litem is required to conduct a full investigation of both homes of whomever is requesting for custody. So if a mother is requesting custody and a father is requesting custody, a guardian ad litem, if a guardian ad litem is appointed, guardian ad litem will go into both homes and conduct a home assessment or a home evaluation, will speak to all of the witnesses that each party gives to the guardian ad litem, will speak to the child and understand what the child's perspective is and what the child's desires are if the child is verbal and able to communicate those desires to the guardian ad litem. Once the guardian ad litem conducts their full investigation, which will also include sometimes talking to the school teachers, talking to church members, talking to neighbors, talking to coaches, wherever the information leads the guardian ad litem will conduct that investigation. At the end of the guardian ad litem's investigation, the guardian ad litem will write a report, and that report will contain the full investigation and a recommendation. That report is submitted to the judge. The courts, most courts, will rely heavily on the guardian ad litem's recommendation and report because essentially the guardian ad litem is an extension of the court and does the work the court cannot do from the bench. So in relying in that information, the guardian ad litem makes a recommendation, the court relies heavily on that recommendation, and the parties use it to their advantage, and in the event that it's not in their advantage, then they put the guardian ad litem on the stand and they question the guardian ad litem, find out what the guardian ad litem did or did not do, and why the guardian ad litem's recommendation may not be accurate. I did have a case where a guardian ad litem ruled in favor of the other client, of the other party. I subpoenaed the guardian ad litem. I asked the guardian ad litem a series of questions, and I found the errors in her investigation and of course in her recommendation. I was able to do that because I have been a guardian ad litem. I understand what it takes, the information you should find, how many leads you should follow, and how you should gather your information in order to make a full and proper recommendation to the judge. So sometimes a guardian ad litem is essential, and sometimes attorneys have to dismantle the guardian ad litem report in the event that the guardian ad litem report is not in their favor. Most times, guardian ad litems do get it right, and it does allow for the child to have a voice in the courtroom. At Fenwick Thompson and Associates, we inform and we empower. You're not just another client. You're like family. Schedule a confidential consultation today.